Supplementary list, item number 1.
May it please your Lordship.
Yes, Mr. Pandey.
Lordship, this is an appeal preferred by the department against the order passed by Income Tax Appellate Court dated 12th December 2022, Lordship.
The delay of 2 to 9 days. You are entering appearance?
We are entering appearance, my Lord. We've received the copy 10 minutes back, my Lord. We've received the copy 10 minutes back.
So issue notice on the condemnation. 2 to 9 days. What are the reasons? Are the reasons justifiable?
Lordship,
for the delay?
Yes. Lordship, the draft was prepared and it was amended. And
no, not the draft was prepared. It was not before any other forum before that, correct? No.
Lordship. No, Lordship.
Then file an objection. Miss case ITA number 2, 2023. And so on, sir. This is an application for condemnation for filing the. How many days?
99 days, Lordship.
It states 99 days, but on the face of it,
is it 120? Is it 109 days or 229 days?
It appears to be 109, my Lord, as per our calculations, rough calculations.
This is an application
for the delay of 109 days, as reflected in the office notes. Issue notice on the condemnation application. Next paragraph. Mr. S. Jindal is present on behalf of the sole opposite party. Such no further notice called for. He prays for about how much time?
2 weeks time. 2
weeks time to file objections to the condemnation application.
To be obliged, Lordship.
daily list, item number 1.
To see. Yes, Mr. Khan.
May it please, Your Lordship. This is a suo motu PI, and we had submitted our first report, Your Lordship. And as per the last order, we were supposed to submit a structured and detailed report.
No, but the thing is that, you see, I think, like, I mean, we are locals, we know that for burial sites there's no such problems. Only with regard to crematoriums where there's a real problem, where some bridges have a misconception with regard to the purity of cremation.
Absolutely.
And the object, and when these other, they try to cremate their, they raise objections and create problems. So in that regard, I think we better appoint an amicus in this matter.
Absolutely.
I mean, at least to,
And Lordship, the second report, Lordship, we just received instruction we are getting during the course of the day. Pursuant to the first report, we have brought in basic thing, and Lordship is very correct. The issue emerged
mostly with crematorium because with burials it's all structured because they all have dominations and they all have their own burial sites.
Absolutely,
so it's
correct.
not really a problem. Dr. Mozika, will you assist the court in this matter? Yes. Yes. Mr. K. Khan submits that the second comprehensive report.
Within Lordship, we just received instruction. Maybe we're getting within a day. Can a week's time.
Filing a comprehensive report have just been received, and he says that he may be allowed some accommodation. Stop. A perusal of the materials on record reflects that the scope of the PIL has been enlarged to cover the facilities with regard to burial and cremation. Stop. In this regard, it is felt necessary that the assistance of counsel, that counsel is necessary to assist the court in this aspect. Accordingly, Dr. N. Mozika, who is present in court, Dr. N. Mozika, who is present in court, has been requested, has consented to be the amicus in the instant case. Accordingly, next paragraph. Now the list is matter after 2 weeks. In the meantime, whatever materials, copy of the file, materials in the file be
Registry will provide me.
Your registry to provide to the amicus staff.
Deputy.
Item number 2.
It's coming. I can't see.
May I please, Your Lordship?
Where's Mr. Poonam?
My Lord, they have very little to say, my Lord.
My senior is indisposed, my lord. We have booked a flight, but he cannot come.
You ready with the matter?
Not ready, my lord. Let the appellant complete. We will be given a chance to address our case on some other day, my lord.
No. The thing is that you see, we thought that the last date today we will. That is understanding that we will try to complete the matter today.
He was supposed to come, my lord. We have booked a flight, but
My Lord, in fact,
unfortunately,
it was to fix today at their instance only, my Lord. Otherwise, it was.
No, indisposed, so that we have to make allowance for that. We can't.
So we may proceed, my Lord, in that case. We may proceed, my Lord.
yes.
This court's never in favor of proceeding half-baked,
My Lord,
that we have to bake it
no,
again
but my
the
Lord,
next
Your
time.
Lordship will kindly proceed that, my Lord. It was between the government and myself. He is only private party, my Lord. Not so concerned. And in the contempt petition, he is not in the picture. Only the fight is between the government and us, my Lord.
There is a problem, Lordship. There is a missed case which is pending, and he has raised the issue of whether this writ appeal is to be closed in view of subsequent developments.
We are aware of that. Last time he had made a submission that.
No, it's just that, my Lord, the last order passed by this honorable court is sufficient to hold that this miscase is not maintainable. Because, my Lord, this last court, the honorable court observed that all further proceedings that took place after the 4th will be subject to the outcome of this writ appeal, and it will be decided, it will be taken care of by the writ appeal, in the writ appeal at the time of hearing. So that means if it is, once it is closed, then how can it be examined? So therefore, it is bound to be.
His I think contention of Mr. Poonam last occasion is that he filed a application to say that the writ appeal is infructuous
Yes.
in view of the orders passed by the state respondents. That's all. So on that count, he has to be heard that how does he say it's infructuous, because he's a
After
party.
examining-
He's the
after-
person who's sitting now in the managing committee governing body, correct?
Yes, my lord. This is principal.
There, my Lord, there is a stay in this. The entire judgment of the learned single judge has been suspended by the division bench at Imphal, my Lord. Still, the same thing is, everything is happening, my Lord. They have not done any changes. In spite of the fact that learned single judge judgment has been totally suspended, not only stayed, suspended. Still, my Lord, they are continuing with the board and with the management and everything. And that was constituted.
Contempt of that court, then. Lordship, actually what transpired was that leave was granted to the government to pass subsequent orders, Lordship. We never asked for the leave, but the Honorable Court, in all equity and fairness, said that if you are passing this order, you pass a fresh orders. We are giving you liberty to proceed as per the procedure of law and as per the Manipur Education Court, Lordship. What we did was as per the liberty granted to us, Lordship. Now the basic issue which comes up is that, Lordship, even if it's said that as per the claim of the appellant that the order is wrong, Lordship, that order is amenable to challenge in a fresh course of action.
From what we understand is this. Now this court had found the single bench unsustainable, correct?
Lordship.
And they gave leave to the
Lordship,
to pass corrective orders so that the whole matter gets given a quiet. But their stand now is that after that leave was given, instead of bringing a quiet, restoring them to office.
As a counsel, Lordship, I have no right to give an undertaking without instruction, Lordship.
Yes.
That was the first date I appeared, because if prior to that the learned AG had appeared, I appeared as the first counsel to appear. I was ready for the arguments, Lordship. I was under the impression that the matter will be heard and disposed of in finality. I was prepared for the Lordship. But the Honorable Court, when perusing through the documents, prima facie, because the order says it appears on 2 counts in the first para, Lordship, because prima facie view was taken because no arguments could be addressed in finality, Lordship. When a prima facie view was taken that you could have given a pre-decisional notice instead of post-decisional, why can't you correct this remedy, Lordship? Now the issue was that we can initiate a fresh procedure.
Correction of the remedy means in which way has to be corrected.
Lordship.
Now they agree with the correction. The way the correction has been done, correct?
Today, the issue is that, Lordship, the order which has been passed is for compliance of the interim order of the Honorable Court. Now, if they say you are not required to comply with the learned single judge interim order, they have a case, Lordship. But if they say you have a mandatory duty as per the law to comply with the order of the learned single judge, and that action has amounted to making that order and all procedural lapses which has been committed the orders has become null and void ab initio, then they have no case, Lordship. That will be my submission in this case, Lordship.
Okay, okay.
My Lord, Your Lordship, may kindly see the para number 8 of the...
See, one thing, Mr. Sahu, is that what we do to deal with the matter? Are we to proceed or...
Proceed, my Lord. My Lord, I don't know, Your Lordship, may kindly see
Otherwise, you can do it virtually in the next date.
My Lord, my Lord,
We'll give you a short date, otherwise we'll close. We want to close this matter also.
my Lord, Your Lordship will kindly appreciate our difficulty. We have come here, this is the 8th time we are coming, my Lord. It's very difficult for us. We are not in no office, we are not holding any office, and it is very difficult for us. My Lord, it is easier to go to Delhi than to come to Shillong, my Lord.
Of course, no. I'm saying you can do it virtually in the next day.
Yes,
My Lord, there are certain things, my Lord, which may require physical also, my Lord. Your Lordship, only one paragraph, my Lord, my friend is application. Only,
If it is on merit, then we will argue it on
only
merits.
one paragraph of the order passed by this Honorable Court on 4/10/23 is enough to say that the miscase is...
That order has to be read in conformity with the earlier orders. They cannot be read in isolation.
This is in isolation.
When did it start? When did it start? 31st August, you have to
Let
start.
me just, only one paragraph.
Please all have your time. You
Para
all have
eight,
your
Lord.
turns to speak. You don't have to.
Para 8 may kindly be seen, my Lord. Only para 8. It speaks volumes, my Lord. Accordingly, since the state seeks time to explain its subsequent conduct, it is afforded a fortnight to file affidavit in such a all action taken by the state subsequent to the order dated 4 will abide by the result of the appeal and may be scrutinized in this appeal. So where is the maintainability of the writ appeal? Once writ appeal is closed, so as in fluxus or whatever it is, then who is the question of scrutinizing the subsequent action? This court has already held that it will be examined. It's a finding of this Honorable Court, para 8.
Subsequent conduct means passing in the order. Subsequent conduct means subsequent passing in the order. If you see previous orders.
Yeah, look at the order. Thank you.
See this paragraph. See this paragraph 3, the last line, number 1 distance.
Yes.
Well, I don't know, 4 maybe.
One second.
If they have to take any action, that is only to they have to leave it to
Very interesting. I was not sitting the bench before, so my brother has pointed out something which this is order dated 4th of September 2023. Very interesting is para 3.
Yes, but
Yes. It reads, doubtless the relevant appropriate order from Directorate or University in Higher Education will follow. Stop. Since the governing body relevant college to dissolve by the government order of September 29, 2021, which has now been cancelled, the governing body stands restored. So as on today, it's not been restored. And the orders that followed, that means they seek to frustrate the entire process.
my Lord. My Lord, very serious matter. My Lord, just please.
Very serious.
My Lord, Your Lordship, I kindly see, my Lord, kindly hear my contempt petition.
One second. Let's just be examined because
Sorry, man.
yes,
Sorry, man.
I was not fortunate to sit in the benches. Yes, and come to the next order, 4th October, paragraph 5.
4th October, this Honorable Court's, my Lord.
Yes.
What is he?
You kindly read it, Mr.
Yes, my Lord, I'll just. 4th October, yes, my Lord. Para, my Lord.
5. It refers to the early order of September 4th.
Yes, my lord. In order dated September 4, 23, the operative part of the order of cancellation was set out, and it was observed that the appropriate consequential order. Well, in fact, this honorable court appreciated
the paragraph.
Yes. Order for Directorate of University and Higher Education with food follow. It also recorded that as a consequence of the cancellation of the notice of dissolution, the governing body of the college stood restored. It was never restored.
That is what.
Never restored.
If state wants to take some action, they should first restore the managing committee.
Yes.
Then let them go.
Yes, my lord.
That liberty should not be.
They did not restore at all. Not even for one day. We submitted legal notice also.
May I just make a clarification?
Yes, I think we'll reserve it.
Lordship,
We'll pass orders.
just allow me to make one clarification.
Yes.
Because you'll be in perversity if my learned friend's submission
We're
is.
just going by the
No,
trend of
that is the
order of
reason
the
why I
court.
said why I am saying
We don't
that
argue with the
I'm
counsel.
not arguing on the issue. I am only arguing on the issue that how does he say that it was not restored? Is it as per the provisions of Manipur Education Code? We say as per the provision here that restoration is done the moment director passes an order. Direction has already passed on 3rd of September before the order of 4th September was even issued. Now, pursuant to that, what was the necessity for, what was the action to be taken up by them? They was to approach the principal and the new governing body which is already created. Which is already created before the order of 4th September is passed. A third party is already involved in this case. Now, did they approach them? They say, they file
legal notice. We serve legal notice even.
Take down.
Lordship, I may be allowed to submit. That is my humble submission.
No, we will pass orders.
Lordship, without submission, Lordship, that will be, Lordship, it will be, because my submissions
It's
have.
the 8th time it's been heard.
No, I am not yet heard at all.
Yes.
The basic grievance is there of the state, my lord, at this point in time is that without hearing, Lordship, orders have been passed, but I may be allowed to at least explain what is the position in the Manipur Education Code. What is the legal notice? I will just show the legal notice, Lordship.
Listen,
What is the basis of
Please
us?
quieten down. Please
Lordship.
quieten down.
Lordship.
Please hear the court. Now, I believe contempt applications have been filed also by the appellant, correct?
Yes, madam.
Yes.
Item number 6.
Yes.
Item 5.
We will issue notice on the contempt applications.
Before that, I just wanted that if I could be heard for just one page.
No, for a
on the basis of which
the
the contempt has been filed. The contempt has been filed.
As it pertains today,
Lordship.
is that governing body has not been restored.
Lordship.
That lies in the face of the
Lordship.
orders passed by this
Lordship,
court.
may
And
I,
contempt will lie.
may I, Lordship, for Lordship, with all pain and efforts that we have come from Imphal, just to make few submissions, Lordship. I can appreciate your Lordship declining to reject my submission, but not to hear, Lordship.
No, because I'm not hearing you.
Lordship, my submission may be kindly noted. What is the basis on which this notice has been sought to be initiated against me? A legal notice has been sent to me, and that is at page number. Lordship, may I kindly see the page number in the legal notice? Page number 2. It is page number 53, Lordship.
Of the appeal.
53. This is the basis on which the
appeal.
Of the Lordship, my this thing, it is in my additional affidavit and opposition dated 17 October explaining the conduct of the government, Lordship.
Or the last affidavit.
It is in my additional affidavit also, madam.
Additional affidavit, Lordship, running into 111 pages. 111 pages. 17 October 2023, Lordship. Page 53, Lordship.
7 September. Which one you are talking about? Legal notice.
Affidavit, my additional affidavit
19
in
October.
writ appeal number 20.
57?
Additionally, 17 October, page 53.
Yes, page 53.
Is that legal notice? Kindly sit down, I'll just complete it. Okay. It's a notice for taking immediate step for giving effect to the above orders. So they say, after having said everything, they say in para number 3, page 55, what does they say, Lordship? Yes. They say, our clients approach the college for taking over the charge pursuant to the aforesaid orders on 6 September 2023. The order is of 4th September, they say 6 September they approached for taking over that charge of this thing. Then none of the office bearer who have been appointed after dissolution of our client's governing body and which has been kept in abeyance pursuant to above order 1 and 2 orders were available. So the allegation is totally against the office bearer of governing body, not to even to the state. Nor was the key of the room kept with the caretaker Chowkidar of the college. Neither is a aided college is not a government college where the keys are kept with the government lordship or by the commissioner or by the director in charge. It is kept with the principal and the governing body. It is nothing to do, the keys have nothing to do with the governor. Furthermore, the principal of the college was not available. Now, non-availability of the college, the principal at that time cannot be imputed to us. Furthermore, the non-handing over of the rooms and relevant documents are highly illegal and violative of the Honorable Court, which is a clear case of contempt. So this is the basis on which they filed the contempt. Yeah. My submission is that, Lordship, it is not a case we did not pass any order, director or did not pass any order pursuant to the order passed by this court for cancel. Once we have conveyed the order of the decision of the government and the director, as per the Manipur Education Code, saying that the other order stands cancelled, your order, the governing body which they are gets revived automatically. Now the provisions of Manipur Education Codes provides that in such situations, what is the requirement? The requirement is that they are to approach the concerned authorities of the managing committee by giving a copy of the order, because they are not a party to the proceeding now. Now, by giving a copy of the order saying that the court has passed this order, now hand over the charge to us. That has to be shown, that due diligence has to be shown. That was not done. They just go to the office, college, then they file a contempt. Now, principal. Now, if the governing body is not available in the college campus at that point of time, they can hand it over to the principal like letter. Nothing has been said about handing over a copy of the order to the principal. Now, in this situation, they just write a notice to us saying that keys are not handed over, Lord. Now, the issue before the Honorable...
It is the duty of every authority to comply and implement the orders of the court. It doesn't mean that we don't go there. We'll not go there, Mr. Hari. The basic fact, if I understand, maybe I might repeat again that this is the simple thing is here is that the orders of the single judge by this court were found to be not sustainable, and the governing body stood restored. And in this restoration process, entire things have come up. You file additional affidavit to justify subsequent orders. And so the thing for us, what is in black and white is that there are orders of this court, there are 2 orders of this court saying that the governing body stood restored.
With all due regards. Now the thing is, what does the Granite 8 court says, Lordship? The Granite 8 court is there, on the basis of which they are claiming a right. It says, Lordship, I just read out the Granite note, the term of the governing body should be 3 years. Action should be taken up by the governing body, failing which the principal to constitute the new governing before the expiry of the term of the outgoing governing body as to enable. Lordship, the provision itself says, the provision itself says that the steps to be taken up when all governing body is ousted and a new governing body comes in, that an all governing body which is ousted will ensure compliance of the order for the new governing body to come in, Lordship. Then after that, the charge is to be handed over. Now, if this is not done by the all governing body which is to leave, the principal will be in responsibility in doing that. Now, the role of the government is given in para number 8 of this general principle, section 4. The role, it shall be the duty of the director to satisfy himself the governing body is constituted properly. Prior approval of the director is required. Prior approval, Lordship, after the court is already declared, they are already reinstated in the order as per their claim. What more order does the government has to pass to say that reinstatement order is there, Lordship? Already restoration is there on record. Now, for that, Lordship, to issue a notice to contempt to us, Lordship, to say we have not done in respect of a private aided college, Lordship, not even a government college at this stage, would be not be correct, Lordship. For which reason, the Honorable Court did not issue in the first instance, Lordship, notice. Otherwise, notice would have been issued on the first day. No notice was issued till date. Because the Honorable Court is of the view that all matters should be heard in finality, the conduct of the government is to be looked at.
Contempt doesn't mean that contempt brings the bill.
No, I'm not saying that. My submission is that
of contempt and you file affidavit.
My submission is that, Lordship. My humble submission is that
after you can make your submissions after your affidavit has been filed.
Lordship, because the court order says, because
item number 6 now.
4th of October.
Will keep it pending.
4th October, Lordship, the order says that our conduct should be looked into, Lordship. and we have sufficient explanation. I'm seeking, and that affidavit has already been filed, running into 107 pages, Lordship.
In the contempt.
That is the same. In that, this answers to the this present contempt also, Lordship.
Yes.
This answers to the present contempt, because our conduct, we have said, it is no question of malafide is involved.
We heard you, Mr. Hari.
Lordship, it will be only complicating in a matter which already the cause has no more survived, Lordship. It is expanding the scope of this thing issue.
It is not
Lordship directs us to Lordship. There is no direction in the order passed by the court. First point, Lordship. There is no direction at all. We just complied with the order of the court to that extent that we was given a liberty to pass subsequent orders, which we did, Lordship. Right? If it is right or wrong, the Supreme Court order says.
Yes.
Lordship.
Yes, we feel I pass orders on item number 6.
Lordship, before issuing notice, these judgments may kindly. I just want two lines of this judgment. Lordship is in this judgment.
Can be submissions, Mr. Hari. Please, we understand. We appreciate the great effort that you're making on behalf of your clients.
Lordship.
But then the thing is that
because Lordship, in a contempt proceeding, we do not generally argue except saying that we apologize, Lordship.
Yes.
But in this case, because there is no contempt made out, that is the reason my humble submission is that.
Please sit down. Thank you very much.
Lordship, this compilations, Lordship.
Or 2023. Yes, item number 6.
Item 4. 4. Contempt is 4, no?
Or 4, yes. 4, sorry. Heard Mr. P. Sahu, Learned Counsel for the petitioner. Stop. This application has been filed alleging disobedience and violation of this court's order dated 4/9/2023, passed in writ appeal number 20 of 2023 with MC bracket WA number 17/2023, comma, and MCWA number 18 of 2023.
My Lord, one thing, my Lord. Pursuant to direction of your Lordships, my Lord, I have served them copy and furnished the affidavit to that effect. That affidavit has been served, my Lord. Copy has been served. This court directed us to
contempt application.
Yes, my Lord. No, sorry, on the contempt petition. I was directed to furnish copy, which I and file an affidavit to that effect, which is on record, my Lord.
Mr. B.B. Sahu, that counsel submits that pursuant to the orders of this court, the petitioners have sought the privileges are yet to be restored. The governing body, sorry. The governing body is yet to be restored. Stop. The governing body of the school, right down, of this, what's the school? Page 3, first paragraph. This is the governing body of the Nauram Birahari College, Kundrak Farm. You pardon me, I am from my side today. Impal is. However, he submits, in spite of the said directions, these said orders will not be complied. So, also heard Mr. Dari, who is present on behalf of the. You're taking notice on behalf of all the respondents?
There are 2 respondents, Lordship.
2 respondents? Yes. On behalf of, who's present on behalf of both the respondents? Yes. The respondents who submits that no contempt has been made out, as it is not the duty of the state respondents to ensure full compliance, as much as the same as just a government aided college. Stop. Next paragraph. Be that it may from materials on record presently and from the submissions and statements made in the contempt application, letter notice issue to the respondents 1 and 2 to answer as to why contempt proceedings were not drawn up against them in accordance with law. Stop. Mr. Rai, next Mr. Rai, praise funds allowed 2 weeks time to file affidavit to the said contempt application. We'll hear it. Doesn't mean that we're sending you to jail today.
My lord, item 2 and 3, my lord.
I have been a bit vocal, Lordship. I'm sorry, Lordship.
Item 2,
justified.
well, item 2 and 3, my lord. Item 2 and 3, my lord. The writ appeals, item 2 and 3.
Yes, sir. The appeal will stand listed after 2 weeks. When the matters next.
Some kind of interim relief, my lord, because we are very.
Yes, we issue notice of contempt. We're not going to go double into interim relief now. Yes.
50th. Well, let it be listed immediately after, my lord, too, because otherwise, my lord, time, my lord,
Yes, you kindly take a date from the court master, which is convenient. And we'll hear Mr. Pawnam that date also. Yes, I'll record the appeal orders later here so that you made a prayer. Your name? You kindly give your name. Your name?
A. Arun Kumar is in the post.
A. Arun Kumar. Record this. Okay, we'll record that order.
Obliged, Lords.
Madam.
Any mention?
Make offence.
Lordship, I beg to mention item number 32, Lordship.
32.
I'm praying for 2 weeks' time, Lordship. 2 weeks' time, Lordship.
Sorry.
Yes, Lordship.
Sorry. Item number?
Number 32, Lordship.
32. Why is Pramali Sangma again and again?
He's on leave, Lordship.
Repeatedly, 4 rules.
He's on section leave, Lordship.
Doesn't matter. You're here.
Lordship.
How many years you practice now? 1 year?
No, Lordship. 3.
3 years? Then next time you argue the matter.
Yes, Lordship.
Okay.
Lordship.
May I please, Your Lordship, in that event, Your Lordship, after 5th December, let the matter be fixed.
Why?
Because I will be out of station for 10 days, Your Lordship.
This is matter after 5th December.
6th, that will be
On 6th, on the request of the councils for the parties. Yes.
Obliged.
Much obliged.
Lordship, I beg to mention item 34 and 35. Lordship, we have filed our petition for substitution, but the miscase were not listed today. So let this matter come after 1 week.
Okay. MS Isingam submits in 3435 that application of substitution has been filed, but the same has not been listed. She prays that matter come up after 1 week. Yes. Prayer allowed this matter after 1 week along with the Mrs. application for
Substitution.
Yes.
Lordship, I beg to mention item number 36.
Where's the other side? He won't give you time.
I have informed them. I prefer 1 week time, Lordship.
We will
Today,
dispose of this matter today.
I'm not feeling well, Lordship, that's why.
You're looking absolutely healthy. This court can't even see properly, still taking up matters.
Just 1 week time, Lordship.
You've taken medicine?
No.
You didn't take the medicine? Then you naturally feel unwell? Okay, 1 week as a counsel for the petitioner says he is unwell. Yes. Yes.
Lordship, I would like to make a mention of item number 40. Lordship, we are conducting counsel is indisposed, Your Lordship. Pray for 2 weeks' time.
2 weeks, yes.
Your Lordship, similar prayer for item number 38.
38?
Yes, Your Lordship.
Yeah, for whom?
And for respondent number 4, Your Lordship.
Who for the petitioner?
Your Lordship. No objection, Your Lordship.
2 weeks, yes.
Obliged, Lordship.
Obliged, Lordship.
No, please, Your Lordship, I beg to mention item number 43, Lordship. I pray for some more time, Lordship. Mr. S. Sheikh is indisposed, Lordship.
To Mr. Sheikh?
Stop filling up.
After 2 weeks.
Similar prayer for item number 45, Lordship.
45?
45.
Okay. Yes.
Obliged, Lordship.
After next week, you won't give adjournments so easily. This week, court's a bit handicapped. Yes.
Supplementary list, item number 1.
Yes. Yes. Have you received copy? Have you any copies of the judgment?
My lord, we have a downloaded copy of the judgment, my lord, from the website.
Note. You can note in the judgment.
Only 4 cases are pending. List which is there at page 8-9.
Yes.
And you have to see data at serial number 17 of page 9.
Page 9?
My lord, we have a downloaded copy. Senior AG is referring to the downloaded copy.
Oh, yes. Yes. There are cases 18-3, 21-5. Once it been disposed of. Now there are 4 cases.
4
Yes, okay.
cases.
So take down.
And some data has been furnished by the Honorable High Court to Supreme Court Registry, Supreme Court. Based on that, this figure has come. So latest data has to be
Verified.
from the.
Yes. No, we'll get it from the district judges. Yes. Yes.
And the direction is there at serial number 20 and please 13.
Yes.
These directions.
Pursuant to the direction of the Supreme Court dated 9/11/2023, passed in the matter of writ petition (C) number 699/2016 by bracket Ashwini Kumar Upadhyaya versus the Union of India and another close bracket. The instant suo motu case, which has been titled INRE, I-N-R-E, designated courts for MPs stroke MLAs to monitor disposal has been registered. Stop. Next, para 20 of the judgment which contains the specific directions is reproduced here and below. So quote part 20. Stop. Next, with regard to directions, at serial number 3, small Roman 3, close brackets, 4 and 6. The district session judges, all the districts, are directed to furnish reports with regard to if any case is pending in their court. Stop. Further, the courts, the designated courts shall give priority as provided in small para 20 or in the above noted para 20 bracket small 4. As also para 6. Stop. Next, the direction contained in small para 7 will accordingly be carried out, and the computer section will be directed to take necessary steps for the same. Stop. Next, a copy of this order along with the judgment of the Supreme Court in the above noted case shall be furnished to the learned Advocate General, as also transmitted to all the concerned district sessions judges of the courts under jurisdiction of the High Court of Meghalaya. Stop. Next, this is matter for further orders after 3 weeks.
Item number 2.
Yes, Mr. Kumar.
My lord, it is a transfer matter. My lord, presently the petitioner is serving in Jammu and Kashmir, and he has been transferred to Manipur, my lord. He has submitted the application for last leg posting, my lord. At page number 14, annexure 1.
Yes, Mr. Dr. Moisika is still. Whose phone is that? Well, Ms. Hazarika, I want to donate the phone to Legal Service Authority. A lot of PLVs don't have good phones. You have a good phone, the PLVs, they can use it. Yes.
My Lord, the petitioner is presently in Jammu and Kashmir, my Lord.
Oh, right. I mean, is there any scope, is there any policy as such in place for last leg of posting?
My Lord, last
that
leg,
considerations given for...
My Lord, consideration is given, my Lord. But it is not a matter of right, my Lord. Consideration
can never be a matter of right, but has his representation been answered adequately?
It has been answered, my Lord. My Lord, what happened? He opted for 4 places, my Lord. The situation is that there is no vacancy in any of those places, my Lord. He wanted either Delhi, my Lord. If I might just take a lordship to
Page number 14, my lord.
Page 14, your lordship. He wanted either Delhi, Ghaspani, Lokra is Guwahati, my Lord, or Sukhovi. Now there are no vacancies in any of these places, my Lord.
What is the rank?
He's second in command, my Lord. Just below command, my Lord.
Was high post?
It's a higher post.
But then, what is your contention, Mr. Kumar? You said that the representation was not considered, or what do you say?
My lord, in that 4 places, my posting may be considered.
No. I mean, like when you filed, as per the policy, for for consideration, you'd file a representation, correct?
Yes, my lord.
And then what?
It has not been rejected. It is simply rejected, my lord. There is no mention of vacancies and each other thing, my lord.
Where's that order?
Page number 18, my lord, annexure 4. Nothing has been mentioned regarding the vacancies and each and everything, my lord.
When are you due to retire?
Still has about 3 years, my Lord.
31st May 2026, my lord.
Okay.
2 years and 5 months as well, only for my supervision.
So basically, he's trying to avoid Manipur posting.
But Sukhovi is not Manipur.
Not Sukhovi, my Lord. He has been transferred to Kaching in Manipur. He has been transferred now to Kaching in Manipur.
Which part of Manipur is it? Near More?
No, capital movement.
Why didn't you give a speaking order? This order is very cryptic.
My Lord, this appears to be the internal communication, my Lord. There must be a speaking order. I can place that.
Take instructions. Heard Nasadi Kumar, counsel petitioner. Dr. M. Mozika, Leonard DSG is present with so and so. Accept notice on behalf of all the respondents. No further notice called for. So you list this matter after 3 weeks for affidavit.
In fact, in the month of March, he was transferred to Shillong, my Lord. He filed a writ petition in Jammu and Kashmir High Court, and we had to recall that.
Why he refused transfer to Shillong?
He refused to Shillong also, my Lord.
Then, if that brought record, Mr. Kumar, discipline force.
That posting has been done before the completion of my normal tenure.
Doesn't matter.
But then my successful implementation.
There will be difficulty.
No. Let him 3 weeks.
Item number 1.
No question in interim orders in matter of transfer. This 31st?
Yes.
Yes, this is 31st.
My Lord, he can join last leg, but he still has about 3 years or 2.5 years service, my Lord. If he succeeds,
you can join anywhere. If you succeed, that means you get your last leg posting. Yes. Next matter. Yes.
Item
Who's
number
here?
1.
Who prepared a paperwork?
My Lord, I am for the state, my Lord.
What's the matter about? First appeal against which order?
Order of the special judge, my Lord.
How many witnesses were there? Can I get records? You have no idea.
Page number 19, my lord, that order.
No, how many? Kadang tahu apa? Tahu apa? Record the position same kan? Huh?
Evidence for Neverland.
Huh?
Evidence for Neverland.
Neverland.
That has been decided on a technical ground.
There's paperwork necessary. Since everything is not there, we
Not
can.
necessary, my lord, everything is
No, that is
part
part
of the
assess the court, no?
Right.
That's why the court's asking whether how many witnesses were there.
I have
otherwise,
not
if
gone
we have-
through the record.
How many exhibits were there? Otherwise, you go to the court if it's necessary, as is the custom, no, convention. Anyway, records have been received. Stop. Parties submit that paper book will not be necessary, in as much as before the court of the special judge of Session Long, no evidence was led, and the matter was disposed of on a technical issue. And accordingly, this is matter for hearing, and you will go and so on. So.
Item number 2.
You have to make a
Well,
submission.
in this matter, the inquiry has been concluded, my lord. That is reflected in the previous order also, my lord. That is under the examination of the Ministry of Home Affairs, my lord.
So what are we to do?
I'll try to get a copy of the report, my lord, and what extent the government is.
It was never shared with the state government
It has not
also.
been said till now, it seems.
No.
Some more time will contribute.
Dr. Muzika submits that the inquiry has been completed and the same is still under examination by the concerned ministry. He submits that, he prays that some more time be allowed to be able to obtain a copy or to obtain instructions. At least after 2 weeks or 3 weeks. Yes, Mr. Pasky.
Lordship,
Mr.
item-
Pasky's appearance.
Item 12, then 22 to 12, then 29, 30, 31, Lordship are connected.
Together, yes. Okay.
13.
Yes.
Yes, respondent number 5 was supposed to find its residence.
Final opportunity was given last time.
We communicated with the department, my lord. But no instructions come, my lord, till now.
Then we'll close the affidavit by the department. Is a compensation matter only?
No, Your Lordship, this is a contract.
Payment of this.
Payment of.
This is regarding payment here.
Which department?
This is a national highway.
Construction of road.
Ministry of Road and Transport.
Construction of a bridge, Your Lordship.
They've been served on newly impleted 4 and 5. They were served. That is Chief Engineer National Highway and Regional Officer Ministry of Roads has been served. They were served on
So far, it's appearing.
Mr. Muzika is appearing for the.
Who?
Mr. Muzika, Senior Counsel, Mr. Muzika.
You're paying for 4 and 5.
5, Your Lordship.
Minister of
In fact, Your Lordship, I had made a submission on Friday that there's a similar matter, which is WPC 30 of 2023.
Wrongly recorded. Actually, it's 1, 2, 3 is
State.
state.
We filed, Your Lordship, the affidavit.
You already filed.
We filed long time back, Your Lordship, yes.
Response number 4 is also from the state government, my lord. Chief Engineer, National
Yes.
Highway, Public Works Department. Meghalaya.
Yeah, there. Colony is appearing for them, for him. Only 5.
Only 5, I am representing, my lord.
What should we do then? We'll close affidavit and pass orders.
Some time.
Many times, my lord. But they are only asking for more time.
Where is he stationed?
Necessary, my lord.
You'll ask his personal appearance on the next date. In spite of final apology being granted, the respondent number 5 who files affidavit. Stop. In spite of opportunity being granted to the respondent number 5 to file his affidavit on being impleaded on 6/7/2023. No, Tommy. Respondent number 5 was impleaded by court order dated 6/7/2023. Stop. Thereafter, numerous opportunities have been granted to the said respondent for filing of the affidavit, and by order dated 31/10/2023, final opportunity of 2 weeks was given to respondent 5 to file the affidavit. Stop. Next part. Today, when the matter is taken up for consideration, the learned Dr. M. Mozikala DSG submits that instructions are still yet to be received.
Not a small submission. My lord, what they've said, my lord, this is a very old matter, 2008 matter, my lord. And they are not able to trace the reports, my lord. That is why they're taking time, my lord. This is the letter I've written.
When is the letter dated?
This is 16th November 23.
So, no?
Today, when the matter was taken up for consideration, the DSG, Dr. M. said the instructions are still yet to be received.
But however, the respondent 5 has communicated the fact that as the records are very old, pertaining to the year 2008, they are yet to be traced out. Stop. In this the matter, he prays that some more accommodation be given.
Yes, for 4 weeks.
Yes. Accordingly, for the interest of justice, 4 weeks for the time granted to the respondent number 5 to file affidavit. Should have said that letter was then.
Apply.
14. 14.
Your Lordship, 14 I enter my appearance on the full respondent.
Yes, Mr. P. Paske has an appearance today on behalf of the respondent service complaint. What do you want? We listen for hearing.
3 weeks time to attend.
What affidavit? There's no reply required here, so still revision.
Small affidavit.
You come and argue it personally then. Yes, list after 3 weeks for hearing, yes.
Oh, bless. 15. We have our affidavit, Your Lordship.
Well, yes, I have received the affidavit filed by the respondent, whereas they remain silent to what I'm aggrieved with.
What do you agree with?
Kindly look to my petition, which is page 13.
Now, what do you agree with? You're not been paid the full amount.
Yes, yes. The pending salary of the petitioner withheld from the date of termination till date. This
That's
is
how much?
Right from the date of termination is 6/4/2017 till the order, till the particular.
Are you entitled to that? Does the court order allow you that? Where's the order of the court?
Page 13, my lord.
Is one appeal also this matter? No.
No, my lord. Point number 3, my lord.
Now what did he say? Not admissible?
No, my lord.
What did he say in the affidavit?
They stated only the point number 1 and number 2. Yes, they have complied with that. Even I don't deny. Whereas the point number 3 has not been.
What is point number 3?
To release the pending salary of the.
No, pending salary they've released, you said, right?
Yes, my lord. With help from the date of termination till date.
Where is that? Where are you reading from?
Page 13, my lord, of the order. Annexure 1.
To release the pending salary of Srimati Malsha Khala with help from the date of termination till date.
My lord.
Yes. You don't release that?
Yes, Your Lordship.
Not release it. See the page 13, yes, that small Roman 3.
Your Lordship, I'll have to stay.
Where's Mr. Yubin?
It's on my Your Lordship before another court.
If that's correct, then you have to drop. You have to issue notice of contempt. Why he should be punished for contempt now? Because notice of contempt and contempt proceedings are two things you all know. You file a small rejoinder then to this one.
My lord.
When was the affidavit filed?
On the 7th.
7th. Yes, sir. Affidavits on behalf of respondent 1 and 2 has since been filed. Mr. Kashim submits that the affidavit not disclose as to whether the order has been complied with in its entirety. He prays for and allowed 2 weeks time to file the rejoinder to the same. Then we'll see after that.
My lord. Highly blessed, my lord.
16.
My lord, this is a case where I was, by the impingement orders, I was restrained from collecting rent and not to disturb the position of the plaintiff. Whereas in my lord, actual position, the suit is all along in my possession. I am collecting the rent. At no point of time the plaintiff has ever possessed a.
You're the plaintiff?
Yes, Lordship.
Okay.
Inventory.
Yes. Please for admission hearing.
It's order column.
Yes, Lordship. It was listed on the last order was for admission hearing, Lordship.
Malay? Yes. Yes, Mr.
My lord, may I take my lord to the impingement order, page 88. Operative order, operative part, my lord, page 99.
88.
99.
Operative part is?
99.
99, okay.
Therefore, I am inclined to grant the ad interim injunction in favor of the petitioners, and I hereby restrain the opposite party, her agents, any person acting on her behalf from encroaching, trespassing, collecting rents, selling, registering, disturbing, interfering with the peaceful possession of petitioner, or to cause any harm or injury to the suit property situated at Nomansong, Dongkamon, Shillong, Eskasi Hills, which bounded as follows. order, my lord, page 100. Considering
What are the reasons why the injunction was given? Prima facie case was established by them, that means. So against this order, what have you done?
I didn't say order, I did appear and sought the permission of the court to file a show cause on
You
this.
file a show
But,
cause then?
no show cause. I was not given a long date was given, so I was
Then that matter
compelled
is
to.
premature, Mr. Suna.
At this point of time, my lord,
Considering
considering
the entire
that
rigor of the civil procedure, I mean, whatever it is, you file a show cause, let the injunction matter be decided.
my prayer till such my show court be and may be heard, that the status quo be made. That will be solved, my lord. Matter can be remand back, my lords.
You will remand back the matter, no doubt, but the thing is that you have come prematurely. I mean, only show cause been filed, that a date, where's the date fixed? It says
Date is fixed on the 7th November 2023, Lordship, for filing of the show cause.
on?
And thereafter it was
7th November.
You file a show cause.
We are yet to file, my lord.
Then?
Lordship, the interim order was passed under Order 39, Rule 1 and 2, Lordship. And they could have, they had the options to address the grievances, Lordship. So this
You
is
can
not
file for
maintainable at
vacation,
all,
you can
Lordship.
file for alteration, you can file, then even you have recourse to decide also to first appeal against the order.
Yes, Lordship.
But my lord, we kindly appreciate the position, the difficulty of
See, you
the
cannot
petitioner.
just
She's
come
all
and
along.
jump, you can jump the forums and
She's
come.
all along collecting
You
the
can't
rent, so
come and
it's,
jump the forums and seek, instant justice, because you have to go through the rigors of the.
If it is a
So
status quo,
why haven't you filed a show cause?
Well, we have
The
short
interim
time,
order
but it was
dated?
given a long
They could
time.
have
That's why we
vacated the
approached this honorable
interim
court.
or they could have filed an application to vacate that also, Lordship. And either they could have filed a revision before the higher court, Lordship, but they didn't do that. They straight away came and invoked under Article 227.
This is a matter from the council.
Yes, my lord.
Yeah, this is council. You could have filed an appeal.
Yes,
from
Lordship,
this order,
they can
dismissal
appeal,
appeal.
Lordship.
Because under CPC you cannot.
Order 39
Yes,
Rule
my
3
lord, I
is
will
clear.
file, but
Under the rules you
status
can
quo will
file.
maintain till such time, my lord. Because I am collecting the rent, I am in possession of the suit land. So if this order is
You are
allowed to
collecting the
serve,
rent now. You are collecting the rent.
No, Lordship.
I'm collecting the rent till dates, my lord. I'm maintaining the suit land, so at no point of time the plaintiff has been ever questioned.
This revision application.
Lordship, if I may just be allowed, Lordship.
Yes.
Even if Lordship, if for a moment, Lordship, submitting without admitting it, Lordship, if they say that we have the rightly or wrongly that has been the order has been passed by the lower court below, then Lordship, I'll just take you to that this in here only, Lordship. That is that page in the order itself, Lordship. The lower court below, on finding that there was a prima facie case, the three essential ingredients fulfilling that, Lordship, she had passed this order, Lordship. So, Lordship, if I may be allowed to read before passing any order and all, I'll just take Lordship to page 95.
No,
Here,
we're
Lordship,
going to pass other orders. We're not going to say that they correct the rent
because,
something.
yes, Lordship, because they, this also, Lordship, and
Let them deposit, the tenant deposit, let you, whoever corrects the rent deposit to the court or something.
Lordship, that will be good.
Or you're not agreeable to that.
No, one thing around the
How much rent are you
courts,
collecting all total?
hotels.
Anyway, there's a question that need not be answered. You see, but one thing, Mr. Norum, is that there has to be something in place. You cannot be a vacuum. It'll create other problems.
Lordship.
That's the only thing. So, as on the date of when injunction order was passed, who was collecting the rents?
I'm collecting, my lord.
They were collecting, Lordship. Then the only thing here is, Lordship,
Then
they have not shown.
Half of the
Yes.
portion of the
In the
property I
plaint
am
itself,
occupying, my lord.
Let the injunction matter be heard finally.
Lordship,
Yes,
the
yes.
plaint itself.
And then
But till then, sir, status quo be maintained, my
within
lord.
4 weeks that will be decided.
Yes.
Yeah. Take down. This revision application has been preferred under Rule 6 of the High Court of Meghalaya, bracket jurisdiction over district council courts, close bracket order 2014. As read with Article 227 of the Constitution of India, assailing the impugned order dated
16/8/2023,
passed by the presiding officer, subordinate to Council Court, Shillong, in this case number
29, 69, 2002.
69 of what? Of 2013?
The miscase
The
is in
typing mistake, my
miscase
lord,
is
I may
number
be allowed to.
16 of 2023, Lordship.
16 or 69?
16. It's written 16, Lordship.
Let's see the order.
Orders miss case number 69, my lord.
69, yes, 69 of. As per separate copy. From no? Presiding officer. 69 of 2023 arising out of title suit number 29 of 2023. Stop. By the impugn order, the petitioner has been restrained. By the impugn order, the ad interim injunction had been granted in favor of the petitioner, restraining her agents and assigns.
Lordship, if I may be allowed to submit here why
Yes.
it was restrained, Lordship. Because, Lordship, it is in the, here, Lordship, she is not the wife.
We're not going to the merits here. We're not going to the merits. Merits will be gone into at the time when the injunction matter is heard.
Lordship.
And if the only prime side satisfied, then let him file a show cause.
That
restrained. If not, this is not order of the court.
By the impugn order, an interim injunction has been preferred in favor of the
Has
petitioner
been granted in favor.
restrain her agents and assign
From encroaching, trespassing, collecting rent, etc. Stop. Next paragraph. The grievance as put up by the petitioner is that though the matter is a very nascent stage and the order is ad interim in nature, which will still be subject to consideration by the trial court, the long date given by the trial court for filing of show cause and for hearing the matter has compelled her to approach this court by way of the instant application. Stop. MS SK Nongrum, who has entered appearance on behalf of the party respondent, submits that the matter is yet to be adjudicated fully and no final orders of injunction, and the final injunction matter is yet to be heard. So the same is not disputed by the lawyer for the petitioner, S.M. Suna. Stop. Accordingly, on perusal of the materials on record and on submissions of the learned counsel parties without delving to the merits of the case or to the claims and counterclaims, in view of the fact that the matter is yet to be decided by the trial court on the injunction matter, this civil revision application is closed with the following directions. Stop. The petitioner herein, who is the defendant of the party in the pending suit, shall file the show cause to the injunction application within 1 week from today. Stop. The trial court thereafter, on receipt of the same, shall dispose of the injunction matter preferably within a period of 4 weeks thereafter. Stop. The parties are put to notice 1 week to appear. 1 week from now is to appear on 24th.
My lord, humble prayer. Till such time the honorable court decide on it.
2023 before the learned trial courts. Till the injunction matter is finally decided, the status quo shall be maintained by all the parties as regards the suit premises. Yes.
Obliged. 17.
Yes.
State has filed the affidavit in order. Some delay in order.
Yes.
May please, Your Lordship. May please, Your Lordship, I received the copy today morning, so
Yes.
3 weeks time may be given to us to seek instruction from our clients.
Yes, affidavit has been filed in behalf of the state respondent. Stop. You are Mr.
E. Lalu. Mr. E. Lalu.
E. Laru.
Lalu.
Lalu. Oh, yes, it is. Mr. E. Laru. Please that he may be allowed. Submits I just received copy of the same. Please will have to examine the same. And please that he may be allowed to file a joinder if necessary within 2 weeks. Just thereafter and so on.
Highly obliged.
18.
Please, Your Worship. Your Worship, in the last occasion, Your Worship, I pray for time to file rejoinder, Your Worship. But the petitioner, Your Worship, could not come to Shillong due to health issue. So I was health issue, Your Worship. So I was instructed that we will proceed with the hearing, Your Worship. We will no longer file the rejoinder.
Okay, Mr. Dean Yota submits that on examination, it appears that rejoinder affidavit not be necessary. Okay, stop. Accordingly, just a matter for hearing in the usual course after so and so.
19.
Your Lordship, I pray for 2 weeks' time, Your Lordship, to file my rejoinder.
When did you file affidavit? What affidavit did you file? Last time you got okay. How many times? Sorry.
2, Your Lordship. 2 times.
This is the third time.
Your Lordship.
After third time, no rejoinder will be closed. It will not be recorded in order, but we won't allow it. Yes, MSP was found, please find out for the 2 weeks time to file rejoinder affidavit. Yes, thereafter and so on.
20.
Lordship, I'm praying for 2 weeks' time, Lordship.
For what? For what?
The list of documents and this one is the Lordship.
List of documents?
Yes, Lordship.
What is this?
That is actually the contract matter, Malay. The matter was already rendered infructuous prior to filing of the writ petition.
That wrong, that withdrawal wrong. Withdrawal.
Yes, Your Lordship, yes.
Nothing survived in this matter, Malay.
2 weeks, Your Lordship.
Mr. Sama is not here. This is matter to 1 week for the orders. Other request. Sorry, this as Mr. P.G. Sama is not arguing counsel is not present. This is matter for 1 week for the orders.
21.
We have, Your Lordship, we have filed a rejoinder.
Let's file it.
Lordship, I'm praying to file a civil rejoinder to the rejoinder filed by.
You can't file rejoinder to rejoinder, sorry.
Civil rejoinder, Lordship, because they have brought in certain facts, Lordship, to which.
Rejoinder, the beings are complete. You can't file rejoinder to rejoinder. That'll be the first time, I think, creating new precedent.
Lordship, they have brought in certain new facts and documents, Lordship, to which we need to reply, Lordship.
What documents? Is regarding that the construction of that path?
Your Lordship. Slab, Lordship.
What documents are brought in?
Questions of facts, Lordship, which they have brought in. That's why, Lordship, we need to revert to those points.
Where is that? Where is the affidavit? Where is the rejoinder? Where is the rejoinder?
Your Lordship, we filed yesterday.
No, where is it? I mean, where have you said that? Where you brought in additional facts? Which is the part? Tell me.
Lordship,
Tell the court.
The photographs, Lordship, says otherwise, Lordship, because we are saying that this drain which they are projecting, Lordship, is not in use anymore. It has been diverted. It has been diverted, Lordship.
No, but the municipality is there. They should address this issue.
But we have already issued a notice to them for removal.
Remove with a red arrow. What is this indicated red arrow? What is this?
I don't have a copy of this.
It's not clear.
What report was filed by you? Report was filed by whom?
Report was in previous round, my lord. This is the second round, my lord. After this matter was filed, we issued a notice dated 17th of August 2023 for removal of the
Green or slab.
So, my lord, now they have to comply with this notice which we have issued. The law will take its own course, my lord. This matter, my lord, nothing is surprise. We take action, my lord, in accordance with law.
No, but what are you objecting to, Mr. Chanda?
This the photographs, my lord, which they have brought is not the veracity. This is not correct because the drain, my lord, it has been diverted, and what they are saying, my lord, is the drain is still in continuance and the water is flowing from that.
That this court will not go on to disputed facts.
There are disputed questions of facts, lordship. That's the only reason, lordship. They are projecting something else before this court, whereas it is otherwise, lordship.
Otherwise, my lord, I would suggest, if my lord, re-inspection is conducted,
Will not complicate the matter further. We'll dispose it after 1 week. It's still in order column. In this matter of the 1 week, Mrs. Changrakso is appearing as
Your
a.
lordship. Hello.
You bring your senior next day. At the request of the parties. Rejoinder affidavit has been filed by the petitioner. This is matter after 1 week for further audiences.
22.
We leave it to you. Let them whatever happens.
Please, Your Lordship. Your Lordship, I pray for 2 weeks' time to file a rejoinder.
2 weeks time has prayed. Allowed for rejoinder affidavits.
23.
Lordship will be filing the affidavit in the course of the day.
Yes, a fresh affidavit as allowed by this court by order dated 20/10/2023 will be filed in the court as it is submitted that the fresh affidavit will be filed as allowed by this court by order 20/10/23 will be filed in the course of the day. Yes, after 2 weeks.
24.
May it please your lordship, I'm praying for further 3 weeks' time, your lordship, to file the affidavit.
No objection. Yes, further 3 weeks time as prayed. Allowed by affidavit.
25.
Much obliged.
May I please, Lordship? Lordship, I'm praying for further 2 weeks' time to file our affidavit.
1 to 5.
And for respondent number 6, your Lordship.
Yes. As prayed by respondents by MS Ailingma for 1 to 5 and Ivasa for R6 for the 2 weeks time granted. Yes.
26.
Which matter?
26.
Please, your lordship. I'm praying for further 2 weeks' time to file the affidavit.
May I please, your lordship? Lordship, we have obtained the status report on 29/9/2023.
On
29/9/2023.
yes, on spot number 5 they've been served.
Yes, your lordship.
Yeah, okay. Your name?
T.A. Sangma, lordship.
Your name is T.A. Sangma?
Yes.
MS T.A. Sangma, as the counsel behalf of the petitioner, submits that the status report has been received on service respond number 5. She prays for and is allowed to file affidavit indicating service system. A new one, Mr.
2 weeks' time to file affidavit.
Further, on behalf of respondent 1 for prays for and is allowed for the 2 weeks' time to file affidavit.
Hearing. Item 27.
May it please your lordship, I pray if this matter may be called up after some time, since learned JSG is still on legs.
Mr. M. Chanda is online, your lordship.
Who's online?
Mr. M. Chanda.
I can see him.
Yes.
in that case.
Let it matter come after 2 weeks as the SG is not available presently.
Authorized.
37.
Please, Your Lordship. Your Lordship, the Additional Advocate General, Mr. K. Khan, he's on legs, Your Lordship. He's on his legs.
You're there?
He's conducting this matter, Your Lordship.
This is the Nepal matter?
Yes, Your Lordship.
In fact, even the counsel from Government of Assam is not
on board. Have you filed affidavit from Assam?
They have filed. If I may pray, my lord, here, my lord, we were concerned with what had happened is the petitioner's son died because of drowning.
While swimming.
Amongst another 30 people who were present there. And they have stated in their affidavit, my lord, that the investigation is going in the right earnest. If I may pray, my lord, if they can give us a copy of the...
In the affidavit you said that what happened in the investigation?
Your Lordship, the investigation is going on, Your Lordship.
It's not complete.
Not yet complete.
When did the incident happen?
This happened on Lordship 9th of March last year. They have said, my lord, that certain statements have been taken and so on. So if they can produce the report, my
No,
lord.
just know the stage of investigation. Is it nearing completion or what is it?
No, Your Lordship, they're still they're taking a statement, Your Lordship. A certain the mobile phone which was supposed to be seized, Your Lordship, that cannot be recovered. So they have contacted the family members of the deceased, Your Lordship.
The thing happened on 7th of March 2023. You think the mobile phone now would have any relevance?
Because the mobile phone, certain messages were there which they claim that that is...
That have been deleted by now, but can be obtained from service providers.
No, in fact, we also have some of those, like the family members of the petitioners have some of those messages. So we are more than willing to give it to the IO.
We've already sent a WT message.
No, but
also.
have you taken them from the petitioner's family?
We've sent them a WT message, Your Lordship.
To the petitioner's family?
Yes, Your
To
Lordship.
do what?
Till now, to retrieve the mobile.
Inside here, the council, you should inform.
In fact, we have also instructed the petitioner's family to go and approach the IO. If I may pray, my lord, let us await the outcome of the investigation.
Mr. SDEP submits that the investigation is still on. MS Lingma submits investigation still on. And praise the matter with them for 2 weeks to enable the apprise of court as a stage investigation. Yes. It is further observed that it's further noted by this court. Further noted. It is further provided that the investigating agency, in case they need to contact the petitioner's family, can do it through the counsel who's appearing before this court today. Yeah, let them contact it through you, otherwise, this accordingly.
That's it, right? Obliged, Lordship.
Much obliged.
Yeah.
In this matter, we have brought forward our some authorities with regard to the...
What authorities?
Lordship, with regard to the continuing process.
Continuing cause of action?
Cause of action, Your Lordship.
Mr. Paul not here?
He's here, Lordship.
He's here in the court?
He's here.
You ready to the matter, Mr. Advocate General?
I am ready.
Where were we last time? When was it taken up last?
This is the case, my lord, where the agreement and work has been executed in 2008.
Yes. Yes.
And provision has been made seeking
Yes.
direction to the state or to the respondent to make the payment of 1.5 crore an order amount. There is a detailed contract, there is an arbitration agreement, there is a provision, everything is over long time back. 1 minute of the meeting is being relied upon to say that some amount is due, and that minute of the meeting is also not correctly So we have a number of objections with regard to maintainability of
You already filed your application against maintainability?
I have already filed the affidavit in this matter, reading all the objections. It is on record.
Lordships, this matter was, as a matter of fact, heard at length by your Lordships. Your Lordships would recollect. The only issue that survived was, and that query had fallen from your Lordships, we had pointed out, my lords, that there are these minutes of the meeting where there is an admission on the part of the respondent. My friend was not even there on that relevant day. His able junior was there. Mr. Okay. Sahai was there. Yes. So, my lords, what we had pointed out was that there is some kind of an admission on behalf of the respondents, insofar as there being an amount due. Now, an objection had been raised by them in the affidavit that even assuming there is some kind of admission, it is time barred. Okay. Because the minutes of that meeting, my lords, which they are relying on. Sorry, page? 5733.
No, one thing, Mr. Paul.
My lords.
See, before, like, the only thing is that these things are still clean, right?
My lords.
So, they, as I recollect correctly, they said that file a civil suit. Number one.
Lordships.
Arbitration.
No, it was on the issue of stale claim, my lords. And your Lordships, what the query that had fallen from your Lordships is whether there is any authority on this aspect of
continuing cause of action.
Continuing cause of action, my lords. We found the answer to that, my lords. That is answered in the Ram Janambhoomi matter, my lords. In the Ram Janambhoomi matter, the Honorable Supreme Court has now answered that matter. That once there is a wrong, my lords, every date where that wrong is perpetuated is a continuing cause of action.
You're saying that is the admitted amount?
Yes, my lords. That the Annexure 16, page 573.
So there's no dispute of entitlement?
Lordships. So once there is it cannot be disputed, my lords, it's their document. That is why, if your Lordships recollect, originally an affidavit was filed whereby they had disputed this. When we had raised an objection, they withdrew that affidavit and they filed a fresh affidavit.
Can't reflect anything.
Well, lords, I'll very quickly refresh your Lordship's memory, my lords. There are two affidavits which are here. The first affidavit, my lords, this document that we're talking about, my lords, is at Annexure 16, and it is relatable to paragraph.
Annexure 16 writ petition?
Yes, my lords. Paragraph number 16, my lords, Annexure 16. Now, initially the affidavit that was filed, my lords, so far as paragraph 16 was concerned, at page 14, my lords, this was the first affidavit. This was filed sometime in, I'll just give your Lordships the date.
Withdrawn, said, withdrawn.
Lordships, because they had disputed it, my lords. They say the contents of the corresponding paragraphs are vehemently denied being false, frivolous, vexatious. The description of the meetings in the corresponding paragraphs are denied as false and fabricated. We had raised an objection to that. Then an order fell from your Lordships, my lords. I'll give the date of the order. Well, it's order dated 28/4/2023. Because it's specifically with regard to para 16.
28/4.
28/4/2023, my lords.
Yes.
The affidavit filed by the respondents is not in correct form. Moreover, certain averments have been made therein which should not have found place with regard to replies of the statement made in para 16 of the writ petition. Para 16 is what I'm referring to, my lords. So, my lords, Mr. So-and-so, for the respondents' praise, they may be allowed to withdraw the affidavit and to file a fresh. Thereafter, my lords, they file a fresh affidavit. This was filed on, my lords, the 23rd of May 2023. And my lords, in this affidavit, there is no answer to paragraph 16.
What does the minutes say?
Well, it's the minutes. I'll take your lordships to the minutes, my lords. Page 573. Well, this is the minutes of the meeting for service tax of RGGY scheme in Jaintia Hills district held on 26/8/2014 in the offices chamber of Chief Engineer Lumjingshai Shillong. The members present is my lords, the Chief Engineer, the Company Secretary, Superintending Engineer, Executive Engineer, Chartered Accountant, and the proprietor, my lords. The penultimate paragraph, my lords, it says, in view of the above, it was decided that the outstanding bills of Messrs. Marvening Enterprise may be processed for payment with due compliance to the audit observations in this regard.
Yes, Mr. Attorney General, so what reply do you have to this?
In the affidavit, they have not responded to para 16, my lords.
That means 2014, this...
Now, you lordship kindly see what is the case all about.
The only problem I'm still having these aberrations, no, just reading. That's the only
We could have it on some other date, my lords.
After 25th, I think should be okay.
We can have it on the first week of December, my lords, if it is inconvenient to your lordships, because it's otherwise a bulky matter.
No, yes, because I have some issues.
Because on that aspect of, my lords...
No, see, the thing is quite clear, Miss. The only thing is that you have to process. If that is correct, that means that it's admitted. See, the question admission is there. Writ petition maintainability against certified and admitted dues. You know, so if that is, you see, it's not admitted dues. You see, it's not admitted.
Where is the denial?
Yeah, affidavit signed in.
I told you, your lordship will see the RGGY scheme. Minutes only, I spoke of minutes only.
We'll not go there. We'll go by the latest. The minutes reflect that. Sticky wicket, Mr.
I'm here also. I'm on minutes also. And there are a number of issues which are there in this case.
Lordships have it on
because action is satisfied with that, I think.
Because I was stuck on that. I argued continuing cause of action, but your lordships had indicated that some authority. Now that's backed up by the Ram Janambhoomi matter.
Let's see. Yes, this is matter further hearing. We'll keep it part heard. First week December.
First week of December.
Matters remain part heard, yes.
Well, I would only pray if your lordships don't have it on the 5th of December. Well, it's 4th and 5th. It's a little difficult. 6th or 7th.
Right. Part heard, yes. We'll finish it off.
41.
Well, it's this matter we had indicated to your lordships that a similar issue had come before the Honourable Division Bench. The Division Bench has held, my lords, that contempt proceedings in these kind of matters are not maintainable.
Is that correct, Dr. Mosika?
But here what happened, my lord, there was substantial amount of outstanding, GST outstanding by...
So undertaking was given for...
He gave several undertakings, several interim applications were filed before this Honorable Court, my lord. And none of the, after giving undertaking, none of the undertakings he abided by, my lord.
This is a similar matter, this one?
Well, this matter pertained to electricity dues. The electricity department had filed a contempt, my lords. Paragraph 6, your lordships may kindly see. Paragraph 5 and 6, there was a default clause.
Yes, Dr. Majika. This is violation which order?
My lord, if I may just point out, there are several orders, my lord. My lord, the first order is, let's say, may have some other day also, my lord. I'll refer to 3-4 orders, my lord. I have to refer to 3-4 orders, my lord, the detailed orders.
No, this is matter also. That request the parties.
42.
Right. Okay.
Yeah, please, Lordship.
Yes.
Lordship, this is a case, second round litigation which has come before this court, Your Lordship, this case was, the petitioner here, she was promoted to the post of LDA. Thereafter, Your Lordship, after the second DPC, she was promoted on the first DPC, which was held on the 30th 11/2020. Thereafter, Your Lordship, on the second DPC, she was reverted back to the previous post of typist, merely on the basis of office memorandum, prevailing office memorandum.
What office memorandum?
I will take Your Lordship to page 46, Your Lordship.
What's the early order? What is this? In the same cause of action, this is page 54.
Early order, Your Lordship, is to dispose of my representation.
Reverted back to the post typist grade 3. It is.
Yes.
His office memorandum is 16/3006.
Yes, Your Lordship.
That a typist who opts for grade system shall continue as such, and he shall be eligible for promotion to post LDA, respective of his 13 service. So you opted for grade system.
I'm not opted, Your Lordship. In fact, there's a letter calling for.
No, the thing is that now with the grade system, that means. One second. So where's the order on the representation?
Page 58, Your Lordship. 54. Oh, 58, Your Lordship. They simply upheld the order by relying on the office memorandum, Your Lordship. My submission is that office.
Yes, what is your submission?
Submission is that, Your Lordship, that office memorandum may be applicable only in the absence of a service rule. But here the petitioner, she was appointed according to the service rule, and her promotion also was referred as per the service rule. And thereafter, Your Lordship, basis on the complaint, submit. If I take Your Lordship to DPC, to the second DPC, Your Lordship, which they have referred. Page 44, Your Lordship.
No, the simple case, if this court understands, is that if you opted for the grade system, they won't be eligible for promotion. That's all. But the only one question is that did you opt for the grade system?
I've not opted, Your Lordship.
Then,
Your Lordship, if you
how do you say that you've opted for a grade system? And if you offer a grade system, that means that memorandum will be applicable to you, which this entitles you to promotion under the under the normal.
Your Lordship, if can you please look at the notice
44.
inviting me to appear for the speed test? That is at page 28, and the relevant part which they have referred to. Page, if Your Lordship come to page 28. This is dated 11 August 2016. May I read, Your Lordship?
No, this is seen. You've seen this, only that you are called for speed test.
A copy of the notification. Enclosed, please find a copy of the notification so and so dated 5/12/2012 from the Secretary, which is self-explanatory for your necessary action. That notification is on the next page, Your Lordship. Page 29.
Yeah, the type. What does the notification say?
Sees amendment in exercise of power conferred the proviso of Article 209 of the Constitution of India. The Governor of Meghalaya is pleased to make the following rules further to amend Meghalaya Directorate Establishment Ministers Service Rule 2010. Relevant part is amendment of Rule 11, Your Lordship. Rule 11, point number 2, Your Lordship. A typist with typist grade 2. A typist with a minimum of 3 years of qualifying service in grade 3 shall be eligible for appearing the speed test of 45 words per minute to be conducted by the MPSC, and their placement in the grade shall be subject to passing the speed test.
Yes,
Here,
so?
Placement shall be subjected to passing the speed test, but the petitioner here, she did not pass the speed test, Your Lordship, and she was still lying in the same post.
So your argument is that you'll only be placed in the grade if you pass the speed test.
Yes.
You haven't passed speed test to remain in the original position.
In the original post, Your Lordship. Thereafter, the DPC was conducted, and as per the DPC, Your Lordship, my name was recommended based as per the rules, Your
Just show the office memorandum.
Office memorandum is that page 46, Your Lordship.
Because that means that does it only one thing is that can it be construed that once you appear for the speed test you've opted for a grade system?
That is a question, Your Lordship, because I have not opted. They call for calling for candidate who willing to appear for the speed test. So I've participated in the speed test.
By very fact, when speed test, that means does it mean that you have opted for a grade system?
No,
irrespective of the fact you fail or pass.
No, Your Lordship. In fact, as per, if Your Lordship, the rule also says that if Your Lordship kindly come to Rule 9.
Okay, let's go to office memorandum first.
Sorry, Your Lordship.
Office memorandum. Yes.
Office memorandum was on
2046. Just say what does it say? Promotion scheme for typists.
Promotion scheme for typists. The undersigned is directed to say that pursuant to the government decision on recommendation of the third Meghalaya Pay Commission announced a resolution number so and so dated so and so, the Governor of Meghalaya is pleased to decide placement of typists in 3 grade as indicated below.
Yes.
Typist grade 1 rupees so and so, typist grade 2 rupees so and so and so, and typist grade 3, Your Lordship, in 3 grade 3. The placement of the typist in the 3 grades on their option shall be subject to the following condition. Grade 1. Typists with minimum of 3 years of qualifying service in grade 2 shall be eligible for appearing the speed test of 60 words per minute to be conducted by Meghalaya Public Service Commission, and their placement in the grade shall be subject to passing the speed test. Grade 2. Typists with a minimum of 3 years qualifying service in grade 3 shall be eligible for appearing the speed test of 45 words per minute to be conducted by MPSC, and their placement in the grade shall be subject to passing the speed test. Here, Your Lordship, even their placement in the grade shall be subject to passing the speed test.
Okay. Then, existing
ordinary grade typist shall henceforth be categorized as grade 3 typists. Number 3, existing ordinary grade typists who have already passed the speed test of 45 words per minute shall be eligible to be placed directly in grade 2, and those who have already passed the speed test of 60 words per minute shall be eligible to be placed directly in grade 1, provided that they have rendered a minimum of 3 years of qualifying and satisfactory service in the ordinary grade. 4. With introduction of the 3-tier system, typist grade are advanced increment hitherto admissible shall cease to operate.
Okay, 5A.
Point number 5A, Your Lordship.
Yes.
A typist who opts for the grade system shall continue as such, and he or she shall not be eligible for promotion to the post of LD assistant irrespective of his or her seniority in the cadet service. Appointment to LD cadets shall be open only to the cadet of grade 3. Appointment to LD cadet shall be open only to the cadet of grade 3 typist until he or she is eligible for such promotion as per the provision of the service.
Yes, now
rule.
5C is option once exercise final.
Yes.
But where have they exercised option? You think by sitting for a typing test they've exercised option, Mr. Ishmael?
If Lordship is kindly come to page, Lordship kindly come to page 28, Annex 3 of the writ petition.
Now the only case is that I never opted for the grade system.
Yes, sir.
And I wanted to go stick to the cadre system.
Lordship.
So if you had passed, you would have gone to LDA, you would have been satisfied.
That statement, in fact, is not correct. Your
28.
Lordship, kindly come to page 28, Annex 3. That is the letter issued by the registrar PWD Roads, Lordship, to the petitioner for that speed test. Then Lordship, kindly come, kindly have page 33, Your Lordship, Annex 5. That is the letter of consent, Your Lordship, by the writ petitioner.
Oh, the letter of consent?
Lordship, yes. Kindly, if Lordship permits, I'll read it.
Yes.
May I read it, Your Lordship?
Yes, read it.
Lordship, this is the letter submitted by the petitioner on 2/9/2016 to the Administrative Officer PWD Roads, Meghalaya Shillong, subject speed test for the typist grade 2. Madam, with reference to the subject cited above, I have the honor to inform you that I, Shimati so-and-so, I am intend to appear the speed test for grade typist grade 2. This is for your. Then Lordship kindly turn to
just
the
to participate in this test.
And then Lordship kindly come to page 34. Then this is the letter issued by the Chief Engineer to the Secretary MPSC, Your Lordship.
See, it must normally work like this now. Once you have qualifying service of 3 years, like they say here, that means you're eligible to appear for a grade. Correct?
Yes, sir.
That'll give you out-of-turn promotion. Depends on speed test. But if you stick to the cadre system only where you're stuck in grade 3, then on attainment seniority, you'll be considered promotion LDA. So the case is that once you opt for speed test and you want to be the grade, that means that you come under a different stream.
Yes.
And so you won't be eligible for promotion under a cadre system any longer.
But Your Lordship, if the rule says different otherwise, Your Lordship, even in while promoting me to the post of LDA, they're referring to the service rule itself.
No, but they overlooked that memorandum. You see, the memorandum is very clear. Now that memorandum was issued to an notification to amend that Rule 11 of the rules, correct?
Yes.
So the thing is that now they say that there's the original system of cadre system where you start in grade 3 and by seniority then you go and you consult for further promotion. And the other cadre system is that you may be in grade 3, but if you attain qualifying service of 3 years, then eligible to take a speed test which will advance your career. So the thing is that once you've taken the decision to sit for a speed test, that amounts to your consent to be put in the grade system. And once you've exercised option, that means that there's no question of reversion back to the cadre system, if this court understands it correctly.
But Your Lordship, what I submit, Your Lordship, is like.
Do you have any authority?
I have some authority, Your Lordship.
That sort of answers this question.
Yes, Your Lordship.
That suppose you opted for a grade system, and on failing to secure any further promotion, that you can revert back to the cadre system and then be given promotion under the cadre system.
Lord, I have some authority which where this office memorandum, which may be applicable only in the absence of service rule. But here the service rule is there.
Okay.
So an executive instruction could make a provision only with regard to a service matter which was not covered by the rules, and that such executive instruction could not override any provision of the rule framed under.
What are the rules here? Where are the rules?
Lordship, the type copy you will find at page 31, Your Lordship.
What is notification?
This notification, service rule is there.
This amendment of rule number 11.
Yes. I have mentioned.
This is the amendment.
So this is part of the rules. See, this speaks about a grade. This speaks of a grade system. They introduce this grade system here,
Yes,
correct?
Lord. Yes.
They introduce a grade system saying that the rule 11(1) typist grade 3 appointments by direct recruitment. Okay. Then, if typists with minimum 3 years qualifying service, that is rule 11(2), which is modified, shall be for appearing speed test, and their placement grade shall be subject to passing speed test. So now they'll be put in grade 2 if you pass speed test.
Then if Lordship is kindly come to page 46.
What service are you referring to then?
That 2000, Lordship.
For promotion to the post of LDA, Your Lordship.
But does it refer to the grade system? Only to the cadre. Which rule you?
It's rule 9. I may read, Your Lordship. Appointment to the post of LD assistant shall be made, number 1, by direct recruitment to the result of the competitive examination conducted by commission. 2, by selection on the basis of merit from among typists of the respective directorate who have rendered not less than 4 years of continuous service on the first day of the year in which the selection is made. 3 is not relevant, Your Lordship. Number 4, the quota to be filled up in the cadre of lower division assistant in any year according to sub rules 1, 2 and 3 above shall be in the ratio of 8:1:1 respectively. This means that 80% of recruitment of lower division assistant shall be by direct recruitment, 10% by selection from among the typists, and 10% by selection from among the grade 4 staff. In the event of sufficient qualified or suitable person not being available in their categories 2 or 3, the balance shall be made up from category 1, that is through direct.
Now your case that the status of this office memorandum, you feel that it is not applicable,
Lordship,
to your case.
Yes, Lordship.
So exciting option. Suppose it works to your favor, memorandum will be applicable. Suppose you pass a speed test.
No, Your Lordship, because there is no. What I'm submit is, Your Lordship, there is no. While this office memorandum is framed in a manner directly to obstruct or to prevent the promotion service, Your Lordship.
No. Where is the memorandum? Yes, okay. This is at page annexure 13, correct?
Yes.
Yes. So you mean to say that with this amendment, everybody is a great typist? There's no more of ordinary cadre typist. What is your case?
Sorry, Your Lordship.
That all are great typists now. That means there's a common cadre. There can't be a differentiation.
So, Your Lordship, the petitioner here, she was right from the beginning. She was appointed.
No, we're not going to appoint. She opted. Now options given to her to take a speed test to further her career, to go to grade 2, correct? And she failed. Now they said that now we have opted for the grade system. So grade system, it says that notwithstanding any seniority, whatever, so that doesn't matter. So the thing is that, see, the 5A, a typist who opts for grade system shall continue as such, and she shall not be eligible for promotion for any aspect of his seniority in the cadre service. This is strange of memorandum. At the provision 5A, Mr. Kulai.
Yes, Your Lordship. My contention is that, Your Lordship, there is a settled position
Then
of
you
law.
challenge this office memorandum.
Your Lordship, yes, I have
You
challenged.
challenged it?
Yes. There's a settled position of law that no government order or notification or circular can be substitute of the statutory rule framed under the authority of law, Your Lordship. I have some authority also in this regard, Your Lordship.
No, we have not challenged the memorandum.
I have challenged.
Lordship, can you come to page 20, Your Lordship, of the writ petition? Oh, yes.
Number D, Your Lordship.
That means now you can't sit for the typing test anymore.
No, Your Lordship. She is eligible for sitting again, Your Lordship. In fact, Your Lordship, she has...
My service after 30 years of regular service, Your Lordship, there's no promotion avenue, Your Lordship, due to this office memorandum, Your Lordship.
Is grade 1 typist equivalent to LDA?
Lordship, grade 2 is equivalent to LDA.
Grade 2, Your
Lordship, the affidavit filed by the state at Para 10 will make the picture very clear, Your Lordship. The affidavit filed by the state at paragraph 10, Your Lordship. Lordship, can you have the state affidavit at paragraph 10?
Or grade 2 is equivalent to LDA? Okay.
Yes, Your Lordship.
Petitioners in grade 3, yes.
She has been given the benefits of the SCP, Your Lordship.
No, forget about that. Only thing is that what Mr. Nongbri is saying is this, that office memorandum will have no application any longer. Notwithstanding opting for sitting for typing test or anything else, it'll have no relevance, because as per the rules, since I come from the the feeder cadre, like all grade 3 typists who can be considered on completion of the service by seniority for promotion to LDA.
That 2010, Your Lordship, has been amended by in 2012, Your Lordship. If Lordship, can you have a rule 11 of that?
No. His simple case that forget the memorandum. You can't take recourse to that any longer.
Then
and that what typists I want cadre on.
Lordship, yes. The amended rule of 2012 is very clear, Your Lordship. Lordship, kindly come to page 31 again.
Of the writ petition?
Writ petition, Your Lordship, yes. Lordship will kindly have typist grade 2.
Excuse me. 31.
Lordship, yes. Lordship, kindly have at 2, Your Lordship. Rule 11, 2, Your Lordship. Typist grade 2. Lordship, got it?
Yes.
If Lordship permits, I'll read it. Typists with minimum 3 years of calling service in grade shall be eligible for appearing the speed test of 45 words per minute to be conducted by the Meghalaya Public Service Commission, and their placement shall be subject to passing of the speed test.
Placement in the grade.
She took part in the speed test, Lordship, conducted by the MPSC. She failed.
The language also is not clear, Your Lordship.
Lordship, for the moment, if Lordship can you come to page 46.
Page?
Page 46, that office memorandum. If Lordship
Let him give him a chance to fight another day. You bring some authorities with regard to how the memorandum will not be applicable at all. That amounts except instructions, and it's not, it's with the field that's already covered by the rules.
I'll file a small written.
No, I don't need that. Just
bringing on record all this.
In fact, Your Lordship, the rule and the office number are in consonant, Your Lordship. The construction of the sentence, Your Lordship, are same, Your Lordship.
Yes, otherwise, once you opted by implication also. Any consent is there also to sit for the typing test?
Just
so you can't consider from the general cadre of grade 3 typers, you're out of the zone of consideration. Because grade 2 is equal to LDA, if what assumption is correct. So then, you're free to sit again.
Yeah, she is free, Your Lordship.
But the word is also not very clear, Your Lordship. Once you exercise.
Exactly. That is what we try to satisfy this court that that in the consideration of the case of the petitioner who failed to qualify, she consented only to sit for the test. She failed to qualify, and so she considered back to be part of the general cadre. That's your case, correct? And also, memorandum should be given weightage to give the warrant in view of the rules.
Okay.
Yes.
Apply, Your Lordship.
Much obliged.
44.
This was beetle not matter. You paid them. Why?
Here what happened, my lord? Beetle nut was seized, my lord.
We understand it was destroyed. Then it's found out to be contraband. So pay them. What will the court do with Dr. Mozika? There's nothing to decide.
Nothing to decide, but this was already settled. There are 2-3 aspects to this, my lord. The Food Safety Act permits the destruction of if the item is not edible, my lord. It's unfit for human consumption.
So it is wrongly seized. That means that it's destroyed, but they won't be entitled to any kind of compensation.
Because one line of submission can be, my lord, even in case of contraband like narcotics, my lord, even if the accused person is acquitted.
That does not hold good at all here. He'll be given the value of the drugs. There can be no analogy under any kind of circumstance. What to do? You fix the amount. What is the amount, Mr.
Amount, my lord, it is at page 25.
Last time you said, what is the amount which was quantified?
88 lakh, as per inventory.
How much? 80 lakhs?
88 lakhs. Page 25 of the petition, inventory. They have assessed the value.
So when can you pay it? Within what time?
Yes.
My lord, that is the difficulty, my lord. Because the department has not gained any revenue. In fact, we have incurred some expenditure only in district.
It doesn't matter.
That's what we're doing the district. And moreover,
you must be having a specific head for compensation.
And moreover, my lord, when the beetle nut was seized, my lord, they came forward claiming for. I'll just place that, my lord. Page 7, my lord, of my affidavit.
Page 7.
Page 7, subpara B, my lord.
Yes.
That, however, without admitting to the matter for the sake of clarification and record, it may be submitted that as per order in original number so and so, dated 6/6/19, a quasi-judicial order passed by the Commissioner of Customs Shillong in connection with seizure of 32 metric ton of betel nut, white seizure case number so and so. It has been mentioned in para 41 that the petitioner Srimati Laltanpui, via her written submission dated 24/9/18, had requested for provisional release of the said 32 metric ton betel nuts for non-consumption use and had prayed for reduction of price of the damaged seized betel nut at rupees 96 per kg, thereby also accepting the fact that the seized betel nut was unfit for human consumption.
No, that's, when can you pay them?
But my lord, the determination of what's
determination is there at the time of seizure. That's as per your document.
My lord, the seizure valuation, my lord, is not market valuation.
So according to you, what will be the amount? What will be the amount that you have to pay?
Because my lord, this remains a fact, my lord. This betel nut was unfit for human consumption. Very inferior quality betel nut. My lord.
Doesn't matter.
No,
it doesn't matter. It does not. How much money are you going to pay us all?
Because the valuation in the seizure list, my lord, at page 25 of the writ petition was done as per thinking that this is a good quality betel nut, my lord. When she herself claimed that it is a 96 rupees per kg, my lord.
So 32 metric tons. So 96, it will come to how much? Is 96 rupees?
No, my lord, it is clarified that at the time this 96 was quoted because as per circular 16/8/2017 for provisional release, they have not given provisional release. That provisional release is to be considered in addition to cost, duty, penalty and redemption fine. All these 10.5% penalty, that is 3 times. 3 times of the value of the goods. That is comes 3 into 96 to 88 per kg.
Pay the amount which pay the interest.
So it is for provision. That has gone. They have not given provisional release.
No. You pay the compensation and we will. You pay the yes. You pay the amount and we will
the
spare the
determination
interest.
of amount, my lord, that is one seriously disputed matter.
There is no dispute, my lord, regarding assessment. It was made by the customs. It is their document. It has reached its finality.
See, you cannot escape the liability.
They are now just escaping their liabilities.
Yes, liability of refunding the
But there are a lot of judgments I have given.
But how much you have to refund, my lord? Because seizure valuation at that time we did not have any report. What is the quality of?
So fine, we will spare interest, right, Mr. Dasuta?
Yes.
Or
they may return the goods to me. They may purchase now. Market value is 500 per kg.
There's no question of return. They've destroyed it.
Now, if they cannot give me the assessed value, it is their assessed value.
But why is it every day you see the news that they're seizing betel nuts? Every day is coming the news, betel nuts are being seized.
Betel nuts is a big business, it is all coming from this Myanmar betel nut going to UP for pan masala.
If there's no good demand from India, then there won't be smuggling. What to do? Nothing to decide here.
Nothing to decide. I mean, it is a settled position of law that to give the assessed value.
The determination of value.
No dispute regarding determination. It is already affirmed by the Tribunal, High Court, Supreme Court. It is assessed value.
Even if liability, my lord, we are fastened with liability, how much will be the liability? That question, my lord.
It is their assessment. They cannot deny that.
Order of confiscation has been set aside.
Yes, set aside.
That has been set aside.
Yeah.
So
and the goods has been destroyed. So we have to pay, my lord.
Pay.
So pay
how much will you
how
pay?
much to pay, my lord? That is
this is their value.
You can't beat on the bush.
Because
otherwise, if you don't come on an amount on next date, if you pay 80 lakh, will give interest of around 18%. Since the date of seizure. When was the matters? When was the good
2017. 6 years.
6 years, 18%.
Yes.
Lord, our case is, my lord, seizure valuation that was shown, my lord. They are asking at seizure valuation, my lord. Seizure valuation, when we do seizure valuation.
See, Dr. Mosika, even if we do a market value at that point of time, suppose you say, okay, what's the commercial value of.
At that time, 300.
Even then, if you take that ballpark figure and you add interest and penalty and other things, it will come to crores. 32 metric tons. 32 metric. It's a huge amount. That's like 3 trucks.
2 trucks.
One truck supposed to carry 10 metric tons.
Special trucks.
2 trucks. We'll give him one last opportunity.
I'll talk to them.
Last opportunity is granted to the respondents.
Your Lordship, send the matter for a civil court to determine the valuation.
How it is not for after 6 years?
How determine the valuation?
Yes. So I am putting some case references regarding.
Not necessary. Task force is granted to the respondents to indicate the exact amount payable.
Or we can get some material. What was the market value of that?
Payable on the goods which have been found to be illegally seized but have since been destroyed. Will you stop for 2 weeks?
Much obliged.
Just about 2 weeks. Otherwise, we'll pass order. See, the court just airing his view. 88 lakhs or with some interest.
Some exchange price or something we can get out of that period.
See, if you go by the price of dried betel nuts,
it is not
that quality betel nut.
Doesn't matter.
It was infested with this.
That adds to the flavor. You know that. Yes.
Much obliged.